I spoke with Joshua Matz, who filed a friend of the court brief in the case of Masterpiece Cake Shop on behalf of theological scholars who say the rights of all and the dignity of all customers must be protected. He also happened to have clerked for Supreme Court Justice Anthony Kennedy and gave us a window into how he thinks the 9 justices might be seeing this case. Is there a possibility that since this is not a protected class at the federal level, they could say, you know, we actually agree with Congress in this case?
Colorado has undertaken to protect gays and lesbians. Some parts of the country haven't. One of the questions here, if the court concludes that the bakers were engaged in protected expression or that they were discriminated against on the basis of their religion, one of the questions that follows is whether the government's interest in protecting gays and lesbians is sufficiently compelling to justify requiring the baker to nonetheless comply with the anti-discrimination laws. And in thinking about that question, the court does have to think more generally about when does the government have a powerful interest in protecting particular groups against mistreatment. And if the court here says that protecting gays and lesbians isn't important enough, there are going to be a whole lot of cases that follow this, asking about whether protecting women or disabled persons or Jews or any other number of groups is sufficiently important. And I have to say, I think that would be an exceptionally awkward and unwelcome position for the court to be in, essentially voting year after year on who's important enough to enjoy the anti-discrimination laws and who isn't.
The baker has said, this is my art. I should be free to express it how I want and to put the words on there that I want. If I don't want to put these words, I shouldn't have to.
Once you say that any activity involving an element of personal expression or creativity is art, and I can assure you that there are books that explain how almost everything under the sun has an artistic element.
Sure.
Once you say that, what follows from it is that almost all of human activity, including the vast majority of activity in commerce, can plausibly be characterized as art or as having a protected element. And once you say that, what seems to follow is that the First Amendment requires the strictest judicial scrutiny of any law that in any way burdens that, which would include all of anti-discrimination law and a whole lot of other regulations that make our society safer and more decent.
You have worked as a clerk of Anthony Kennedy. Of course, the big swing justice, you were there during the big Obergefell case. Now you're not there, but you know how both the court and the most important Justice Kennedy work. Where do you see them likely coming down?
Well, let me start by fighting the premise a little bit. I would not take for granted that Justice Kennedy is the only potential swing vote in this case. In recent years, Justices Breyer and Kagan have expressed sympathy for free exercise claims, and the Chief Justice has made it clear that he is worried about putting courts in a position where they are knee-deep in the most bitter and divisive social issues. And so I think it's entirely possible that this case could go in any number of directions. You know, when this case reaches Justice Kennedy, the fact is that it presents claims of principle and claims of dignity on both sides. And this is a hard case. Lawyers don't always like to say that. It is. The values implicated here are profoundly difficult, and they resonate on both sides of Justice Kennedy's jurisprudence. It's hard to say how exactly he'll resolve them. It's hard to say whether there even is a middle ground to be had here. But we can rest assured that the Supreme Court will, I think, look to find a way that produces an outcome that's fair for the nation as a whole.